Well, good afternoon, everybody, from a nice sunny location outside of the Manitrock courthouse here. It's a very pleasant sunny day. Obviously very significant, this particular location. I've got a couple of photos that I'm going to share with you first of all. Just to let you know, because it was posted on, this one here, posted on as a comment on one of the videos, and it's from Carrie Skinner. Rally for Stephen Avery and Brendan Dassey, July the 25th, from 2 till 7 p.m. at Warpond at the Dodge Correctional Institute. So if you're able to get along in a couple of weeks' time, well, in fact, today's what, the 14th, so 11 days' time. If you're able to get along to Warpine, Wisconsin, outside the Dodge Correctional Institute, rally for Stephen Avery and Brendan Dassey. Please do pop along and support the guys. The other photograph I've got here, which is obviously quite significant, is this comment by Seth Waxman, the 41st Solicitor General of the United States. He put, "I have never had a case that has troubled me more than Brendan Dassey's case, that has kept me awake at night, that makes me anxious and sad. And that is because I know that Brendan Dassey is innocent." Let me put my little microphone on. "And that is because I know that innocent. And I know that no judge, not the state trial judge, not the state court of appeals judges, not the federal district judge, not any of the judges on the Seventh Circuit, including the 4 judges sitting en banc who denied his petition, not a single justice sitting on the Supreme Court thinks otherwise." Excuse me. So I think that's quite significant. That, as I say, that Seth Waxman feels so strongly about the Brendan Dassey case, and assures us that there's nobody, none of the judges think he's guilty. So you have to ask the question, well, how did he not get released? How did he end up there? We know about that, but how did the this supposed wonderful legal system in America that we hear on more than one occasion, judges saying that they like the system, and that this particular, like in Orlando Hudson, it shows that the process works. It shows that the system works. So what is it about the system that is the problem in Brendan's case? Let's pop that back in and let's finish off the third part of the Brendan Dassey appeal in front of the same judge that heard the case. This is the big problem. Simply the fact that because this appeals court was in front of Judge Fox, there was no way he was going to admit that anything was done wrong the first time round. You know, that's just ridiculous to think that any judge would have the gumption to admit to having done something wrong. You got to remember, he's voted on every year, every 4 years. He has to go up for re-election. And it's the fact that Judge Jerome Fox obviously stuck to the jury's original decision. There was no way he was going to go against the jury's original decision. That then, by Judge Duffin, was deemed to be unreasonable because Judge Duffin decided that no other judge in the whole of America, would have recognized Judge Fox's decision as being reasonable. And of course, the big problem was that when it went to the Seventh Circuit, Judge Hamilton dissented. That then meant there was a judge in the United States, one single judge, Hamilton, by his dissenting against Williams and Rovner. That was the reason why immediately Brendan had lost. Obviously, it went to the en banc hearing, and we all know the rest. But anyway, let's carry on with this part of the final part of the decision by Jerome Fox. Hard going, although it might be. So, yes, trial counsel's failure to deconstruct the March 1st confession as ineffective assistance of counsel. In his brief, Dassey reprises the contaminated confession argument that he raised with Dr. Leo's post-conviction testimony when he claims as deficient trial counsel's failure to systematically deconstruct Brendan's March 1st confession so that the jury would understand that each corroborated fact in the confession was a product of external contamination. He claims that each of 19 details in his confession that the state presented to the jury as corroborated by physical evidence should have been deconstructed by counsel at trial because each of those so-called facts could be traced to either Dassey's innocent knowledge of events or his acquaintance with the news media reports, or arose from contamination introduced by the investigators who questioned Dassey on March 1st. In short, the jury heard testimony about purportedly corroborated evidence that actually emanated from non-inculpatory sources, and trial counsel was deficient by not forcefully bringing this to the jury's attention. The state responds to this by pointing out there is no proof in the record that Dassey obtained the information he now calls contaminated from other than his own personal experience. Additionally, it discusses some of the post-conviction testimony of trial counsel who asked Dassey where he got the information that he used in his confession and why he falsely confessed. According to that testimony, Dassey never adequately explained to either Attorney Fremgen or Attorney Edelston the source of the details in his confession or why he might have falsely confessed. Just one moment. My wife's trying to contact me. She clearly doesn't know that she's not to contact me while I'm in the middle of a live video. So let me just send her a quick message telling her that I'm otherwise engaged. Okie dokie. Sorry about that. Just run through that paragraph again. According to that testimony, Dassey never adequately explained to either Attorney Fremgen or Attorney Edelstein the source of the details in his confession or why he might have falsely confessed. The two attorneys said in their post-conviction motion testimony that Dassey told them he might have dreamt it or got it out of a book. The appropriate measure of attorney performance within professional norms is reasonableness under, the circumstances of the case. State versus Brooks, for example, of 1985. Dassey provided little or nothing to his trial counsel that they could have used to deconstruct his March 1st confession. His trial testimony, both on direct and cross-examination, provided no evidentiary platform on which trial counsel could construct a plausible contamination attack. Instead, it created, through Dassey's own words, an explanation for his March 1st confession, which lacked any credibility and added to the negative weight of his original admissions. Moreover, much of what Dassey maintains about the deconstruction of his confession by either Dr. Leo, another interrogation expert, or trial counsel comes at a remove of more than 2+ years from the trial itself and rests entirely upon assumptions as to what testimony would or might have been and how that testimony would have played out to the jury. The court considers much of the post-conviction testimony on deconstructing Dassey's confession through either defense counsel or an expert more speculative than convincing. The court finds trial counsel's performance with respect to these matters to be within the realm of reasonableness, considering the circumstances of the case. And it's this reasonableness that was the big issue that Judge Duffin quite rightly said, no, that's not reasonable. D. Video clips of Dassey's recantation. This is something that often gets talked about. Why didn't the last bit of the video, March 1st video, get played? Dassey's post-conviction motion faults trial counsel as being deficient for their failure to insist upon the admission at trial of several video clips from the March 1st, 2006 confession. The clips, which post-conviction counsel categorized as a recantation of Dassey's confession to police, occurred after the end of police questioning while Dassey was speaking with his mother, Barb. The text of the video clip reads, Brendan, what happened if he says something, his story's different? What he says he admits to doing it. Barb, what do you mean? Brendan, like if his story's like different, like I never did nothing or something. Barb, did you? Huh? Brendan, not really. Barb, what do you mean, not really? And we all know the next line, they got to my head. Post-conviction counsel seizes on the phrases not really and they got to my head as being Dassey's recantation of the confession he had just given to the police investigators. Testimony at the post-conviction motion hearing showed trial counsel differed on showing this video clip to the jury. This is very interesting. Attorney Edelstein thought the jury should see it, while Attorney Fremgen did not. As lead counsel, Fremgen made the strategic decision not to play the portion of the tape because he thought it depicted a mother coming in to see her son and realizing he had just done something serious and would go to jail. This was not deficient performance. Counsel made a rational decision based on an evaluation of the information and emotion the video clip would convey to the jury. Apart from that, to suggest, as post-conviction counsel do, that these remarks somehow constituted an unequivocal recantation of Dassey's previous confession is a dubious proposition. At best, the terms "not really" and "they got to my head" are, in the context of the conversation between Dassey and his mother, ambiguous. Well, folks, I'm sure that you know full well the meaning of ambiguous and have practiced it many, many times. At worst, the words can be viewed as substantiating the confession he previously gave to the police. Trial counsel's claim deficient performance in closing argument. Post-conviction counsel frame as concessions of guilt two statements that Attorney Edelsten made in his closing. The first statement made by Attorney Edelsten, which counsel says represent a concession, appears to do so at least as defense counsel experts Attorney Edelsten's remark in the post-conviction brief. However, when removed from the isolated context, post-conviction counsel gives it appears to concede nothing other than to depict Dassey as being pushed by investigators to say things he truly didn't believe. Edelsten argued, but the truth of the matter is, a couple of times when they weren't specific about who they're even talking about, he gives an answer such as a number, and it changes. It bounces back and forth. He was confused. He was scared. And let's just briefly touch upon that. Ask yourselves, how probing were they when they told him, "I seen it"? And he said, he's seen me see it. So he told me not to say something, or else he threatened me a little bit. He made it clear to them early on, and they had no reason to doubt it. They just didn't like the answers. They didn't like what he said, but they never explored the potential truth and alternative that this young man walked over there and did see something in a fire, and that something was Teresa Holbach. Well, no, they were never going to accept anything other than, "Brendan, you saw it, just say it, and we'll go and bat for you." They go through this scenario and they start. Once he tells them, "I seen it," and Steve knew it, and he said, "Don't say anything." That's when it becomes, "You say this, you saw that." The second part of Edelsten's argument, which Dassey labels a concession, begins where Edelsten talks about the Halloween bonfire and how Dassey went about picking things up for the fire, and eventually they start throwing stuff in there, and he probably did see something pretty traumatic. Dassey acknowledged in his testimony at trial that he had been at the bonfire and helped his uncle put things on the fire, including tires and the seat from Teresa Holbach's RAV4. I don't remember that at all. I remember there being a seat that was put on the fire, but certainly not from Teresa's RAV4. Edelsten's remarks in closing draw on Dassey's own admissions at trial, but in no way suggest that Dassey committed either element necessary for convicting or mutilating a corpse as party to a crime. Even if this court concluded that Edelsten's discussion of Dassey's appearance at the bonfire was a concession, it would not be ineffective assistance of counsel. State Silver, State Gordon, both of which Dassey cites in his brief, give counsel leeway to concede on account if counsel's decision is tactically reasonable. At the post-conviction motion hearing, Attorney Edelsten did not recall making any frank admission of Dassey's direct involvement in the corpse mutilation, the charge that carried the least significant penalty, but he did acknowledge making an argument which was intended to provide that as an option to a jury. The court believes this falls within conduct permitted under Silver and Gordon. Trial counsel's alleged deficiency in failing to get Dassey's February 27, 2006 and March 13, 2006 statements admitted into evidence. Defense trial counsel sought to have admitted at trial all or portions of Dassey's February 27, 2006 interview at Mishicot High School with Bert and Ernie, Dassey's March 1st, 2006 interview with the two Muppets had been heard by the jury, and that interview, as well as some trial testimony that had made mention of a discussion with the defendant on February the 27th. After hearing argument from counsel, this court, citing State versus Pepin and Wisconsin statutes 90801, ruled that the state could use any inculpatory statements made by Dassey since they constituted an exception of the hearsay rule. The defense could not, however, use exculpatory material from the February 27th interview unless it was intertwined with the inculpatory statements and bore the same guarantee of trustworthiness. Dassey now says that trial counsel performed deficiently by failing to cite the right evidentiary rule for the admission of the February 27th and May 13th statements. His trial counsel, he says, should have urged the court to admit the statements because they weren't being offered to prove the truth of the matter asserted, but rather as examples of Dassey's suggestibility. This court finds nothing in Dassey's post-conviction argument that would cause it to rule any differently than it did at the time of the matter. Was the time that matter was initially argued, and the court determined the statements to be an inadmissible hearsay. Even if the statements were admitted as requested by trial counsel, the weight of the evidence against Dassey was such that there is no reasonable probability that the outcome would have been different. Post-conviction counsel also contend the statement's admissibility should have been argued by trial counsel under the completeness rule codified at Wisconsin Statute 90107. This court understands that statute to permit the admission of otherwise hearsay evidence if it is necessary to provide context and prevent distortion. But neither the February 27th nor the May 13th interview of Dassey was necessary to complete or fairly balance other trial evidence. Trial counsel did not perform deficiently by failing to use the rule of completeness as a basis for the admission of the February 27th and May 13th statements. Dassey closes that portion of his brief dealing with the deficient performance of his trial counsel by asserting that the 5 instances of trial counsel's deficient performance cumulatively as well as individually prejudiced him, and he is now entitled to a new trial. And he again raises as ineffective assistance of counsel the failure of Kaczynski and trial counsel to seek the suppression of his March 1st statement as the fruit of an illegal arrest. This court believes it has dealt sufficiently with the claim of an illegal arrest in an earlier portion of this decision. As to the 5 areas Dassey articulates as constituting deficient performance of trial counsel, this court has found trial counsel not to have performed deficiently in these instances, State versus Felton. Even assuming that one or more of the complained of acts was wrong, none of them, either singly or collectively, was so serious that the defendant was deprived of a fair trial and a reliable outcome. Strickland versus Washington. Withal, this court has neither seen nor heard anything which creates a reasonable probability sufficient to undermine its confidence in the outcome of Dassey's trial. Dassey's claim to be entitled to a new trial in the interest of justice. Wisconsin Statute 80550 empowers the trial court to set aside a verdict and order a new trial in the interest of justice. Dassey urges the court to affirmatively exercise that power in his case because the trial counsel failed to fairly explore the unreliability of his confession and therefore deprived the jury of trying his case on an informed basis. The failure of trial counsel to deconstruct his confession or call an expert to deconstruct his confession has resulted in a miscarriage of justice, entitling him to another trial or at least another suppression hearing. This court has examined the cases Dassey cites in his brief and can find nothing in any of them which lends support to his claim for a new trial in the interest of justice. State versus Hicks, which he cites in support of his request, was a case in which newly discovered DNA evidence, excluding the convicted defendant, was received at a post-conviction evidentiary hearing. The state had used a hair sample to help convict a defendant, but no DNA test had been done on that sample. Our Supreme Court reasoned that the real controversy was not tried because the evidence excluding the defendant as the origin of one of those hair samples was relevant to the issue of identification, and it was not heard by the jury. Likewise, the defendant in State versus Jeffrey introduced post-conviction testimony that showed he did not have herpes in a case in which the victim claimed her case of herpes originally stemmed from the sexual contact the defendant had with her when she was 3 years of age. On appeal, the court reversed because it believed that the post-conviction evidence could have had a great impact on the credibility battle between the prosecutor and the defendant had it been presented. Both Hicks and Jeffrey were reversed because the respective courts decided that each jury should have had an opportunity to hear the critical material and relevant scientific evidence that was not disclosed until a post-conviction evidentiary hearing. Dassey seeks to have us believe that expert testimony from academic police interrogation experts or trial counsels deconstructing cross-examination exposing the contaminated parts in Dassey's confession would have the same qualitative trustworthiness as the scientific tests referenced in Hicks and Jeffrey. Well, you're right there, Judge Fox, because that is exactly where we are with the science of false confessions. More and more people are realizing that there is a science to this, a science that we can trust. Certainly in a case such as Brendan Dassey's, when his interview, as mentioned earlier today by Mark and Ericosi, it's an example that they use nowadays of how not to conduct an interview with a juvenile. And there is already people are coming forward now and saying, it's about time we stopped allowing police to lie to people that they're interviewing. Anyway, questions of its admissibility aside, the proposed testimony of experts such as Dr. Leo or White would not present any exculpatory evidence for the jury to consider. Fox, you are completely wrong about that. Rather, it would simply allow the expert to offer an opinion about the reliability of Dassey's confession. Opinion testimony and deconstructing cross-examination are a far cry from the evidence in Hicks and Jeffrey, which triggered their reversals. This court cannot find that Dassey's trial represents a miscarriage of justice, nor can this court find that the real controversy was not fully tried. He is not entitled to a new trial, nor should he have another suppression hearing. Conclusion. In his post-conviction motions, Brendan Dassey has claimed that counsel who represented him to and prior to trial were ineffective and performed deficiently on his behalf. Because of counsel's various failures to effectively pursue his defense, Dassey says he is entitled to a new trial in which his inculpatory admissions are suppressed, or alternatively a new hearing to suppress his self-incriminating statements. This court has examined Dassey's arguments on the issue raised in his post-conviction motions. Based on that examination, the court has concluded, for the reasons set forth in the body of this opinion, that nothing done by his pre-trial or trial counsel has rendered the result of Dassey's trial unreliable or the proceeding fundamentally unfair. Well, the proceeding of course, Fox, you're not going to find against yourself. Accordingly, the court denies Dassey's motions for a new trial and a new suppression hearing. The state is directed to draft the order reflecting the court's decision, dated this day, the 13th of December 2010, Judge Jerome L. Fox. So, getting back to here, let's come back here now. So I think, unfortunately, the next part of this process, because we need to go fast forward and look at the decision by the judges that heard the initial argument. We've been through Williams and Rovner's decision. I think we're going to have to look through Hamilton's writing, because he wrote as a dissenter in the initial oral argument, and then in the en banc hearing, he wrote on behalf of the majority. So I think that's where we'll go next. We'll have a look at Hamilton's dissent to the in the seventh en banc oral arguments. Just to change the subject, tonight I've got a live chat with a very, very famous, so famous that he's in the Hall of Fame of the Scottish Traditional Music Hall of Fame, John Carmichael. So if you're around at about 8:30 tonight. So for Dr. Silkman, that's about 5:30 in the morning. So if you want to join me then, all well and good. Yeah, you know what, Dr. Silkman, I was listening to Eric Ose and Mark this morning, and he was talking about a lull, and I don't think there is really much of a lull. There's so much going on. I'm still getting the some of the guilters commenting on the channel, which is quite hilarious, because I've invited them on to come and present their opinion, to try and present any kind of reasonable argument, and they're not prepared to do so. All they want to do is try and attack the messenger of the video, and are failing miserably. But anyway, look, guilters, keep going. It is laughable. You are cowards. You know that, because you're not prepared to come on and debate, because you know that you've no chance. So let's just have a look. Hi, Sharon. Brendan, ironically, was at a disadvantage. Why? There was no forensic evidence. Exactly, yes. Yeah, this is the problem, isn't it? A lot of these false confessions are shown to be false by DNA evidence. Yeah, and obviously once we get to know who left the blood stain on the back of the RAV4, which is neither Teresa's, nor Steve, nor Brendan's, then we'll find out exactly what's going on. Yeah, well, I think that the guilters would, if they ever do come on, I don't think they ever would. And what they're going to argue about is just, the kind of things that they go on about. Basically, if they came out and said to me, well, okay, maybe the end justified the means, I would actually have more respect for them if they said that, Steve and the family, they need to be taken. If this was their opinion that they needed to sort this out, and they couldn't possibly have, Stephen Avery becoming a multi-millionaire in Manitowoc County. If they were to come out and be reasonable about why this conviction occurred, maybe. Yes, parrots of the state, absolutely, yes. And of course, the state is becoming less and less worth listening to. So anyway, I don't know how long we're going to have to wait for Paul Riley to make his decision. But based on the fact that he wasn't very impressed with the state the last time round, I can't see him being very impressed with them this time round. Anyway, as I say, we'll probably start having a look at Judge Hamilton's dissenting opinion first time round. As I say, tonight, John Carmichael. Next week, back with Peter Wood. And I'm hoping I might be able to get a Speedway rider to join me at some point and talk a little bit about Speedway, which is another passion of mine. But anyway, nothing confirmed yet, so I'm not going to say any more on that matter. Thank you all for tuning in. Catch you all again soon. As I say, if you're anywhere near, anywhere in Wisconsin or nearby on the 25th of July, let me just pop that up again for you. Let me just pop that picture up again. This one here, I believe. Yeah. Rally for Stephen Avery and Brendan Dassey, July the 25th from 2 till 7, Warpine, Wisconsin, at Dodge Correctional Institute. So there you go. There's something to look forward to if you're able to make it. Okay, well, thank you everybody. Thank you Mose and Sela and Dr. Siltman, and we'll catch you all again soon. Bye for now.